Hi, I'm Ariss Fong, and this is hearing tip number 5 about hearing panel deliberations. Here are 8 good practices for hearing panels. First, don't wait to deliberate. Hearing panels should deliberate as soon after a hearing as they can manage to meet. This is because the evidence and arguments of the parties are fresh in their minds, making deliberating much easier than if they left it for a period of time. My preference as independent legal counsel, even after a long hearing that might require several days or weeks of deliberations, is to have the panel start their deliberations the day of or after the hearing, and to schedule the rest of the deliberations soon after the first meeting. Second, make sure each panel member has their own copy of the exhibits. Ensure that all panel members can deliberate with their exhibits in hand. When panel members are not all working in the same location, each panel member will then have the ability to review and confirm information in the exhibits. Third, hearing panels should understand the importance of the citation. The allegations set out in the citation are the issues to be deliberated and decided. A panel may also need to deliberate and decide issues of procedure or evidence, but the panel must deliberate and decide all the allegations in the citation. Panels should not decide allegations that are not part of the citation. Fourth, ensure all panel members are engaged with the deliberations. Subject to the legislation, the decision of a panel is the decision of the whole panel and not only one of its members. It's not unusual for one panelist to take the lead, and that's not a problem, but other panelists must participate in the deliberations and make their own decisions on the issues. Fifth, panel members should take lots of notes during their deliberations. It's important to capture each member's decision and their reasons. Later, during the drafting stage, notes become central to the panel's decision and reasons being set out accurately. I'm often asked by panel members whether their notes can become disclosable. The answer is generally no, as the doctrine of deliberative secrecy protects all deliberations, whether in written or oral discussions. There are very few limited exceptions to the doctrine of deliberative secrecy. Sixth, when a panel has deliberated and decided an issue, review the evidence and argument against that decision once more and ask, does it change your mind? If so, then why? If not, then why not? The need for adequate reasons requires that panels demonstrate it has grappled with the main disputes in the evidence and the arguments of the losing party. Seventh, panels should understand what constitutes the decision of the panel. Unless otherwise set out in the legislation, the decision of a majority of the members of the panel is the decision of the panel. And finally, eighth, understand what independent legal counsel can and cannot do. Independent legal counsel cannot conduct deliberations, cannot make decisions. That's the role of the panel. Independent legal counsel can provide advice on procedure or evidence as long as the advice does not engage an issue in dispute between the parties. Independent legal counsel can assist in articulating the decision and reasons of the panel in a written decision. Deliberations are hard work for the panels, and the 8 issues I've flagged for you are only a small part of the process. Hearing panels should receive training and have independent legal counsel available to assist them with decision making. Thank you for watching this clip. I hope it was helpful. Our 6th and last hearing panel tip will be on writing reasons.